Patrick Shepard. Sir, you may begin.
Thank you very much. Good afternoon, and welcome to the Fundamentals series. I'm Patrick Shepard. I'm a lead instructor here at OGE. I'm very pleased to be joined today by Cheryl Kane-Piasecki, also an instructor here at OGE. And today we're going to be talking about applying commonly used exemptions at 5 CFR Part 2640. Before we get into the substance of today's presentation, I'd like to cover a few administrative announcements. Next week, on Thursday at noon, we will be joined by Jeremy Sotenberg from the Nuclear Regulatory Commission and Sean Croston from the Federal Reserve Board. And they will join us to discuss advocating for personal interests in the workplace. So we're going to have a number of different authorities we'll be discussing, maybe some stuff you haven't thought about, some things that are outside the strict definition of the ethics laws and regulations, but nonetheless things we want to be very careful to be aware of. So please look for that and share with your colleagues that we'll be doing that. It should be an excellent presentation. For those of you who participate with the Interagency Ethics Council, Jeremy and Sean will be giving a presentation on the same topic tomorrow, and our presentation is going to be a follow-on to that. So if you're at the IEC presentation and you'd like to learn more, you can check us out next Thursday. If you're not able to make the IEC presentation, you can also join us and learn a little bit more about those authorities. The following week, we plan to do Institute for Ethics in Government Year in Review and Look Ahead. We'd like to share with you where we've been and also where we're going in the next fiscal year. We'd also like to thank you for your participation and your cooperation that made this year a very successful one in ethics education. August will mark Gifts Month. We're going to do a lot of things on the gifts front, including another massive open online course, and this time it's going to be the Widely Attended Gathering MOOC. So if you've been to the widely attended workshop here at OGE, it'll be a similar format. For those of you who have been unable to make those workshops, this is an opportunity for many more people to participate. So we're very much looking forward to that. We'll also be covering gifts in the Fundamentals series next month. So a month from today, we'll be discussing the fundamentals of gifts. And finally, for the Advanced Practitioner, next month we will be covering WAG versus 1353. So if you're interested in learning more about the gifts laws and regulations, next month is for you. We're going to have a lot of content in that area, and we look forward to seeing you. Finally, at the end of next month, we will be doing a distance learning event that is a bit of a summit preview. You may be aware that in September, OGE is going to be hosting the National Government Ethics Summit. And this is going to be a fantastic event spanning almost the entire month of September. And there will be folks who will be live in DC at actual events, and there will be also folks who can attend virtually. So if you're not able to make it to the live event, you can join us for, I think, 27 sessions of virtual content, and we'll be explaining all of that in the summit preview. So should we get started talking about 5 CFR 2640 and some of the commonly used exemptions?
Sure, let's jump in.
All right, should we cut to the slides?
Yeah, let's go to the slides. If everybody could, hopefully everybody had an opportunity to download the slide deck from the max.gov site. And also, if you, we provided you with a copy of the 2640 regs. I promise you I am going to force march you through those regulations, so if you can have those handy, that would be super. And we also had a copy of the exercises that we're going to be walking through, and really this entire presentation is sort of built around those exercises. So I hope you all had a chance to at least take a look at them, if not actually to sort of work through all of them, to at least familiarize yourself with the fact patterns so that once we get to them, they're not entirely novel to you. The other thing, just fair warning, I know it's a massive slide deck, and I'm sure part of you, many of you might be thinking, holy crap, Cheryl, what have we got here? But I promise you, we're going to move through them fairly quickly. And the reason I do that mostly is because not everybody has the benefit of the visual with the Google Hangout. Not everybody is with us on the Hangout. Some folks are out there just with disembodied voices, and I know how hard it is to keep your focus on just a voice. So I wanted to give you slides that'll help prompt you to know what's coming, so that you can make sure that you can it'll help you stay aware and alert for the pieces that you're most interested in. So if we can move down to the second slide I have, I've given you my email address. We are going to invite you to ask questions in the Google Hangout. You'll see there's a sidebar there for you to be able to ask comments throughout the presentation. So as you have questions, please post them there. And as time allows, we will address your questions.
Yeah, I'll keep an eye on those. So if you do ask questions, I'll be able to ask them on your behalf, and we'll address those in a timely way.
And then for those of you who are on the phone bridge, if you can hold your water until the end of the presentation, I promise you we will leave time at the end of the presentation for you to ask any questions that you may have about anything that we cover today. So that's kind of logistically how we're going to handle this afternoon. So if everybody could move on to slide 3. Patrick, I know you and I have talked about this a lot. You know, one of the things that I think that we find as practicing ethics officials, and we've seen it a lot in a lot of the fundamentals training that we do, is that a lot of times folks take shortcuts, with their analyses, and are ready to sort of to jump into things without doing a thorough analysis. So today, I know we're going to be talking about the 2640 exemptions, but I think it's really important for everybody to understand sort of whence the 2640 exemptions come and where they fit into a 208 analysis. Would you agree?
Yeah, I absolutely agree. And I think particularly with the conflict of interest statute, the reason that we tend to shorthand our analysis is because of the financial disclosure process. We become accustomed to providing prophylactic, prospective advice to employees where we don't have complete fact patterns. We just have a sense that a holding or another reported asset might pose a potential conflict. So we have kind of that horseshoes and hand grenades understanding of Section 208. But when we get to the application of specific exemptions and particular analyses, it's really important to keep those ideas separate and to do a detailed and thorough analysis of all of the elements that might be implicated.
Absolutely. And so when we talk about 18 U.S.C. Section 208, I mean, today I want to do a little overview of 208, get us acclimated to how 208 is structured so that we understand sort of the analytical process that adheres in doing a 208 analysis, so you can see where these 2640 exemptions fit into that analytical process. So the first thing I always like to remind everybody is that what 208 is it's a prohibition on participation. It's a prohibition on participation in what we call particular matters. So in order for you to be able to do a conflicts analysis, one of the most critical pieces of information you need is to know what is the particular matter in question. What is the government matter that the employee would be participating in? And then we have to find out, is there any possibility that the employee could experience a gain or loss, a financial gain or loss, as a result of that governmental action on that matter? And if they could experience a gain or loss through some sort of vehicle, it could be a stock, right, Patrick?
Right.
But it doesn't have to be a stock. It could be...
It could be an employment arrangement. It could be an employment arrangement of a family member in some cases. There are lots of ways that an employee could experience a gain or loss. They could experience a gain or loss directly by direct monetary transfer. And that's what we call the financial interest, right? Mm-hmm. The holding that produces the financial interest is a financial holding. It's a stock, it's a bond, it's a mutual fund, and we're going to talk about those. But the important thing is those create the interest in the matter.
Exactly. And 208 is utterly indifferent as to what vehicle it is through which the employee could experience the gain or loss. What 208 says is, no matter what that thing is, if you employee could experience a gain or loss as a result of the outcome of this government matter, then you are disqualified from participating in that matter. Okay, so if you go to the next slide, there is a common misconception that somehow 208 addresses itself to restricting people from holding certain types of assets. And again, 208 couldn't care less through what mechanism you have a financial interest or through what mechanism you could experience gain or loss. It just says, if you can experience a gain or loss as a result of governmental action, you have a disqualifying financial interest in that matter, and you must disqualify yourself from that matter. So we've given you a lot of language. So for those of you who are oral learners, that might have been a very illuminating sort of discussion for you. But for those of you who are more visual, we'll try to give you something that maybe is a little more comprehensible on slide 5. And here we give you it's a Venn diagram, and this is kind of like broken down precisely what Patrick and I just explained a minute ago, which is when you're doing a conflicts analysis, you basically have two critical pieces of information that you need to know, and when you're doing your analysis, what you're trying to see is there a nexus between these two things? So on the one hand, we want to know what's the particular government matter the employee is going to be working on. And then on the other hand, we have to know, is there some vehicle through which the employee could experience a gain or loss? A financial holding or some other form of interest that government matter could affect such that the employee experiences a gain or loss. And it's where those two things collide is where 208 resides. So if you go to the next slide, we're talking about conflict remediation, and here's where the 2640 exemptions are going to come into play. This is where they fit into the conflict analysis. They are a way of remediating this conflict, this nexus issue that we have. Now, because we have two different things that create the nexus, we have two different ways that you could remedy the conflict. You can either, just move on to the next slide to keep moving through this. You can either remove the matter, the particular matter from the nexus, which is you do that by having the employee recuse themselves or you disqualify them from the matter.
And this is usually the default option, right? If
Exactly.
someone finds themselves in a position where they're being asked to participate in a matter that would affect them financially, that they have a financial interest in, their duty is one of recusal.
Exactly.
And other options are things that we can think of more long-term that may be necessary to allow them to continue to work.
Exactly. The minute that an employee believes that they have a financial interest in a matter that they're working on, which is to say that they could experience a gain or loss, they must immediately recuse themselves from that matter. Because remember, 208 is a bar on participation. So the minute someone participates in a matter in which they have a disqualifying financial interest, they have stumbled into a potential 208 violation. And once you've violated 208, I say this all the time, but it's true. Once you've violated 208, it's kind of like being a little bit pregnant. You don't get to be un-208 violated. So the recusal is a default remedy. It must happen the minute the employee believes that they're participating or that they've been assigned a matter in which they may have a financial interest. So if you go to the next slide, this is where we're showing you. You remove the matter, there's no longer a nexus, there's no 208. So by the same sort of logic, now if we look at the other half of that Venn diagram, here we're looking at the thing that creates the disqualifying financial interest. We're looking at what is it that gives the person a financial interest in the matter. And the way that we remedy those, we have several things in our toolkit to remedy those. If it's amenable to a divestiture, and not all things are going to be amenable to a divestiture, if it's a stock or something of that nature, something that can be sold, divestiture is one way you can do it. But there are other ways, right, Patrick?
Right, there are other things we can do. And some cases where you might have difficulty with divestiture is you might have an asset or other financial holding for which there is not a big market. A publicly traded stock is relatively easy to divest, but privately held interest or privately held companies can be challenging. Also, financial interests arising from things like a spouse's employment. That could be a challenging one to work around. So we do have some other options.
Mm-hmm. And written waivers are one of them, and we're not going to be talking about those today. That is a vehicle that you can use, and the regulations that apply to that are also housed in 2640. So that's where you would find more information about issuing a written, what we call a B1 waiver. Those are individual waivers. But what we're going to be focusing on today are these other critters, which are the authority for which resides actually in the statute itself.
The statute itself, yes.
Congress gave us that authority within the statute itself at 208B2, and that's the 2640 exemptions, some of which we're going to be discussing today. So again, if you pull the disqualifying financial interest out of the nexus, again, or out of the Venn diagram, again, if we go to slide 10, you no longer have a nexus, so you've taken care of the 208 problem. So that's kind of like an overview of 208 in a nutshell. So what you need to realize, though, is the 2640 exemption determination really comes after you've determined that there is a 208 conflict of interest. So the exemptions only exist to remediate what is otherwise a 208 disqualifying financial interest. So that's one of the reasons why we're really going to make you do that 208 analysis today. Because when we talk about, sort of taking shortcuts, I think what happens, unfortunately, is people start to become a little bit familiar with the 2640 exemptions, and when they're doing an analysis or when they spot something, they'll immediately look at the thing, the financial holding, the stock or the whatever, and they'll jump to a conclusion about whether or not that might qualify for an exemption without ever having asked the initial question as to whether or not it's a disqualifying financial interest to begin with.
Right.
So that's why we're going to force march you through a 208 analysis with all of the examples that we're talking about today.
And I think that's really important because some of the exemptions apply only to a subset of possible matters.
Yes.
So if you've not figured out what matter, for which matter the asset is potentially conflicting, you may inadvertently apply an exemption that maybe doesn't apply in the case of that matter. So it's really important for us to have all the facts because they change based on the kind of government work that's implicated.
Exactly, and that's why the 2640 exemption is very much like your original 208 analysis, which is you can't do a conflicts analysis unless you know what the matter is that the employee is working on. Likewise, for many, if not most, of the exemptions, you're not going to know whether that exemption even applies unless you know what type of matter the employee is working on. So that's why always, focusing on the particular matter is really, really critical for both your initial 208 analysis and certainly then for determining whether or not your 2640 exemptions might apply. So if we go to the next slide, just a few words about exemptions. And this is just kind of nice to know. Only OGE is authorized to issue exemptions. As we said, Congress gave us that authority in the statute itself. Those exemptions are housed in 5 CFR Part 2640, and we're going to make you very intimately familiar with that regulation today. Now, these next two pieces are really critical, so kind of ears up here. These exemptions apply automatically, and by that we mean that unless you have an authority that trumps ours, and what kind of authority would trump ours, Patrick?
I know some agencies have prohibited holdings provisions in their organic statutes, or have otherwise enacted supplemental agency ethics regulations that bar employees from holding or participating in certain kinds of matters or that would affect certain kinds of interests.
Exactly. So we're looking at you either have to have a separate statutory authority or if you've issued your own supplemental reg that where you placed some prohibited holdings restrictions, those will be the only things that trump these exemptions. Otherwise, you do not have the discretion to say whether or not the employee can avail themselves of these exemptions or not. If the holding that the person has, if the thing that they have that's the disqualifying interest is subject to one of the exemptions, the exemption applies automatically. And when it does apply, this is your last bullet, it mitigates both, not just the 208 piece of it, but it also takes care of any appearance concerns under the impartiality provisions in subpart E of the standards of conduct. And for those of you who are like, wow, I didn't know that, where does it say that? It says it in subpart E of 2635. So if you go to the impartiality provisions in 5 CFR part 2635, at the tail end of 501, at 2635.501, there's this big honkin' note. I mean, it's like half a page long. It's this huge note at the end of 501. And at the tail end of that note is where you will find a discussion about if an exemption applies or if a waiver is issued, that those take care of any vestigial appearance concerns under 2635.502. So just make sure that you take a look at that note, and if anybody questions you about it, that's where that authority is discussed. So if we go down to the next slide, on slide 12, the agenda for today is basically this. We have a process we're going to walk you through for determining whether publicly traded securities will apply to certain scenarios, exercises that we've outlined for you, or whether the employee benefit plan exemptions might apply to our exercises. And once we've applied, we've walked through the process to see if those examples apply. We're also going to be alerting you to some useful resources that you can refer to or help you figure out where do you get the information that you're going to need to determine whether or not these exemptions might apply to certain holdings.
That's the problem I always have is trying to keep all these straight. There are a lot of exemptions, and usually once I find the one that I'm looking for, I don't have too much difficulty applying it. But remembering that they're there and remembering where to find them is really helpful. So I think that's a good takeaway from this course. Is what resources are available to you to help you to identify those exemptions that will apply.
Exactly. So if we go to the next slide, just to briefly outline what the process is we're going to be taking you through today. Number one is the key one I talked about earlier. We're going to be asking ourselves with each scenario that we talk about, okay, is the outcome of the government matter that is addressed in that exercise, in that particular scenario, is the outcome of that matter going to have an effect upon the type of interest that we identified in the example? So here we're going to do our 208 analysis, and we're going to explain to ourselves why it is, if 208 applies, why does 208 apply?
So that's kind of our threshold question, right?
Yes.
If we don't have a potentially conflicting asset, we don't need exemptions because there's simply no conflict.
Exactly. And so so once we've determined that that 208 is implicated with our scenario, then we'll sort of talk about, well, can you see what a potential exemption would be here? We're kind of giving that piece away today because we are only talking about the publicly traded securities and the employee benefit plan. So we're not gonna beat that horse to death because it's going to be pretty obvious. But that is part of your process when you have a set of facts where you're trying to determine what, if any, of the exemptions applies. And then we're going to look at, okay, does this exemption cover this particular type of financial interest? Because different exemptions apply to different types of instruments and vehicles.
And this is a part that I find to be very hard, because we do a lot of work with the ethics rules, but here we have to become a little bit knowledgeable about financial holdings and kinds of financial assets and financial terminology. So this is really important that you familiarize yourself with the definitions.
Yes. Amen. And we're going to be looking at the definitions and be talking about the definitions. The 2640 exemptions are really definition heavy, and they are, very definition dependent. So don't think you know what these things mean. Make sure you know what these things mean, and we're going to show you where to find these definitions and how to interpret them. So then the next one is, does the exemption cover this type of particular matter? And we talked about that earlier, that you're going to have to know what kind of matter the person's working on because different exemptions apply to different types of matters. And then, of course, for the de minimis exemptions, you're going to look at the dollar thresholds, which will apply. And then ultimately, if there are other elements to the exemption, you'll have to make sure that those elements are met as well. But this is generally our process, and this is what we're going to be walking through for the rest of today. Just a brief note on the next slide, which is slide 14. We covered diversified mutual funds and accepted investment funds. Patrick and I did last month.
At length,
ad nauseum. And that's recorded. We had some video glitches last month, but it is recorded.
You can listen to us talk about this.
Patrick, tell them where it is.
You can find it on the Google Plus page. It's actually probably just below this video if you're on the Google Plus page right now. If you can't find it there, you can also find the recording and the materials on the Max page on the distance learning tab of the Institute for Ethics and Government page.
So we're not going to reprise all of that here, but the one takeaway from that we just want everybody to get drilled into their heads is that a diversified mutual fund is a conflict of interest concept. An accepted investment fund is a purely financial disclosure concept. Please do not confuse or conflate the two.
So for the purpose of today's exercise, we can just imagine that there is no such thing as an accepted investment fund because it doesn't matter to us at all.
Exactly.
When we're in 208 land.
Exactly, because we're in 208 today. So, okay. So we're going to move on to publicly traded securities. If you move to slide 16, we've got and we're going to be talking about the first exercise. And I had given you a separate handout with these exercises on them, but just so that everybody is aware of what the facts are that we're working with here. We have an employee who's going to be assigned to work on a regulation. And that regulation will set standards to reduce harmful bacteria at facilities that manufacture frozen dinners. So we're looking at standard setting regulations for frozen food manufacturing, okay? In essence, that's our matter, okay? The employee's spouse and 12-year-old son inherited $2,500 each in Conagra stock last year when the employee's father-in-law died, and the employee also has $12,000 worth of stock in Nestle. So here's the other half of our Venn diagram. We're looking at, these are vehicles that this employee has And our threshold determination is going to have to be, will the outcome of the standard setting regulations affect or create a potential for gain or loss to the employee through either this interest in Conagra stock or this stock interest in Nestle? And Patrick, remind them why the Conagra stock is going to apply here, notwithstanding that it's the spouse and the 12-year-old son.
When we look at the text of 18 U.S.C. Section 208, you'll probably note that certain persons' interests are explicitly imputed to the employee. That includes minor children and spouses. It also includes a number of other persons, people with whom they're negotiating for or have arrangements for future employment, people that employ the employee outside of the government, things like that. So we always want to start with the text of the statute and make sure we know whose financial interests we're concerned with when it comes to the possibility for a conflict of interest.
Mm-hmm. So in this case, we're looking at the spouse and minor child. So those interests are imputed to the employee under 208. So let's go to the next slide. Again, I've just spelled it out here for you because this is the first step in our process. Will the outcome of the matter affect these holdings? And the Conagra Foods, I just wanted to outline for you in case you hadn't had a chance to look up Conagra Food. They manufacture Healthy Choice and Banquet frozen meals. So this is a standard setting regulation that I think clearly they're going to have an interest in. Nestle as well manufactures Stouffer and Lean Cuisine frozen meals. So again, we have an entity that's likely going to be affected by the outcome of this standard setting regulation. And all we did on slide 18, because I'm just trying to, again, reinforce this, that you should always be thinking about these fact patterns in these kind of terms, is to set it up for you into our Venn diagram. So our matter is the standard setting reg, and the things that we're concerned about, and we need to see if there's a 208 nexus, are these interests in Conagra Foods and Nestle, and these are stock interests that the employee has. So how do we analyze stock holdings? I mean, that's one of the threshold issues, is we have to say, okay, well, what the vehicle through which the employee might have this potential for gain or loss are stocks. Yeah. So how do we treat stocks, Patrick?
I think this is a really difficult part, and I think this is an area where there's a lot of misapprehension, both amongst employees and sometimes with ethics officials, about how we look at stocks. And I think this is tricky because it requires us to sort of adopt a legal fiction, which is that when you own a stock, it's as if you own the whole company. It's as if you had an undivided interest in the entirety of the company. So that anything that affects a company that you have an ownership interest in affects your financial interests. Basically, we say that you stand in the shoes of the company when you own stock. Mm-hmm. But that's not obvious. We're not talking about the matter needing to have an effect on the share price. Who knows what drives share prices? If you guys know what drives share prices, let us know and we can all get very rich.
Yeah, you quit your job and go be a day trader.
So we sort of adopt the legal fiction that when you own stock, when you have an ownership interest in a company, you stand in the shoes of the company. So anything that affects the company affects your personal financial interests. And that's not intuitive, but is very, very important to our analysis.
Yeah, so that's why stock holdings almost always are going to be like a really direct 208 conflict, because we take the position that as an owner of the company, anything that can affect the company is going to be deemed to affect your financial interest as a stockholder in that company. So it's a very direct, or in our analysis, it's a very direct 208 conflict of interest. But that's the threshold question we have to ask, is why is this even a 208 problem? So we've determined it is. I mean, if you've got stock in two companies, each of which clearly, manufacture frozen foods and would be affected by the outcome of this matter, we have a potential 208 conflict of interest. The next question in the process would be, okay, well, which exemption might apply to these things, these vehicles that the employee holds? Well, again, this is a no-brainer. We're dealing with publicly traded securities, so we would be looking at the exemptions at 5 CFR 2640.202. So let's do that. Let's get into 2640.202, and I'll give you a minute to get to the reg. Okay, once you get to 2640.202, you're going to see that there are several exemptions that fall within the ambit of this these de minimis interests in securities. 202A, if we look at that one, says DeMinimis exemption for matters involving parties. So here you can see already the direct reference that Patrick and I were talking to earlier, which is that this is an exemption that's only going to apply to matters which involve parties. Okay. If we go to the next one, which is at B, that's a de minimis exemption for matters affecting non-parties. Okay. Now that one is going to be very similar to A in that it's going to deal with specific party matters, and we're going to point you to those definitions in a moment, but I just want you to know that there's a distinction between A and B. And then we get to C, which is a de minimis exemption for matters of general applicability. Okay? So that's a different set of matters. That's a different subset of particular matter. Which we're going to deal with later on when we get to that part of the process in determining like what's the distinction between a specific party matter and a matter of general applicability. But just to give you a general familiarity that these exemptions are going to depend on the matter. So you're going to have to know what the matter is. But these exemptions also have other things in common. So let's go back to 202A. I just want to look really quickly at what 202A says. And 202A says, okay, an employee may participate in any particular matter involving specific parties, so there's our matter, in which the disqualifying financial interest arises from the ownership by the employee, his spouse, or minor children. Now, this is going to be the same across these three exemptions, okay, of securities issued by one or more entities affected by the matter if the securities are publicly traded or a long-term federal government or are municipal securities, and then it goes into the dollar value. But the things I want us to focus on here with this definition, and as I said, this is going to apply to all of those de minimis securities exemptions, is that it's about securities that the employee, the spouse, or the minor children own, and the securities have to be publicly traded or be long-term federal government or municipal securities. So there are some factors here that we have to take into consideration, and there's some determinations we're going to have to make in order to decide if any of these exemptions are going to apply. So let's go to the next slide, slide 21, and that's the next step in our process. The thing here is that it's got to be, these have to be securities, but not just securities, they have to be publicly traded securities.
I think this is one of the hard parts, because
Yes.
this is an area where you might be very familiar with the ethics laws and regulations, but these definitions are dependent upon some fluency and understanding of financial concepts.
Exactly.
And that's an area where we tend to have a little less expertise. So it's very important to reference the actual text of these definitions.
Okay, so let's go to those definitions, and you're going to find those in section 102, 2640.102. And the definition for security is going to be at R.
That is a lot of definitions.
It is a lot of definitions, yeah. And I've got it on the screen there, so we can go ahead and look at it. But I'd like you to physically locate it if you have a copy of the regs yourself. I mean, we've got it on the screen, so we can keep moving. But it means a common stock, a preferred stock, a corporate bond, a municipal security, long-term federal government security, and limited partnership interests. And then it goes on to talk about other things. But for our purposes, generally today, we're looking at common stocks, preferred stocks, corporate bonds, municipal securities, et cetera, et cetera. Now that just gives us the definition of security. We still have to get to the publicly traded piece.
Yeah, in some ways you're not even halfway there by getting to the security definition.
Exactly. So let's go to publicly traded. And when we get up there, we see, it has to be a security as we just defined it, but then it also has to be, under paragraph 1, registered with the Securities and Exchange Commission pursuant to Section 12 of the Securities Exchange Act of 1934. Excuse me. And this is a critical piece here, listed on a national or regional securities exchange or traded through NASDAQ. Do you want to expand on that, Patrick, a little bit?
So that's tricky. So in order for our securities to be publicly traded, it doesn't mean publicly traded anywhere. It means publicly traded in the United States on a national or regional securities exchange. This would be the New York Stock Exchange, the American Stock Exchange. There are a number of exchanges, or the NASDAQ. So if we have securities that say trade on the London Exchange or the Prague Exchange or trade elsewhere, they're not going to qualify as publicly traded for our purposes. And I find that to be very counterintuitive. If this is an area where the definition is extremely important, especially with respect to to securities that trade not on an exchange or trade on foreign exchanges.
Yeah, and the same holds true then for corporate bonds as well. And if you look down at P3, it says the same thing about corporate bonds. It says a corporate bond registered as an offering with the Securities and Exchange Commission under Section 12 and issued by an entity whose stock is a publicly traded security. So again, you're getting at a similar sort of thing. So just so you recognize that that's the limitation that we place on the definition of publicly traded security. So we know in order for this exemption to apply, whatever it is you're looking at has got to be a publicly traded security. So Patrick, if you go to the next slide, slide 22, I've given you a list of various companies here, and I've asked what do these companies have in common. We got Dell, Bechtel, Enterprise, Toys R Us, Purdue, Cargill, Dole, Sheetz. So, Patrick, what do you think all those things have in common?
Well, I'm familiar with a couple of those. The Heinz company, definitely, and also Dell. And I know that neither of them are publicly traded. Dell was once publicly traded, but the founder of the company took the company private again. So my guess would be that none of these companies are publicly traded.
And you would be absolutely right. These are privately held companies. This means that their stock is not publicly traded, so you do not get it on an exchange, and they're not registered with the Securities and Exchange Commission. They're privately held companies. So stock or securities in these companies would not be eligible for the exemptions because they are not publicly traded securities.
And your financial research web services can help you determine whether or not something is publicly traded. Usually I'll put the name of the company in. If it's publicly traded, you'll normally get a ticker symbol and also some information.
Exactly. And what I did, and what Patrick's talking about, I gave you a little example of that for Conagro. On the next slide, I did a screenshot of Google Finance. And, we've got Google Finance on here, but there are any number of other search engines that you could use and get the same information. And what do I have highlighted there, Patrick?
Yeah, it looks like, it says that it's public, and it also says NYSE before it gives us the ticker symbol, which is CAG. And what that means to us, what that tells us, is that this is a security that's traded on the New York Stock Exchange.
Exactly.
And any of the financial research services that you'll use will provide you with this information. If you're not familiar with the acronym that is used to identify the exchange, I would encourage you to look it up. There are a number of places online that will give you the definitions for those acronyms. But something that I'd be particularly careful about, if it says OTC there.
Hang on, we're coming to it.
Oh, are we?
We're getting there.
Excellent.
Getting there. Okay. So the first one we saw clearly, that was the New York Stock Exchange. That's an American exchange. It said it was publicly traded. So what about Nestle? Now, when we look up Nestle, you're going to see something like this, which you want to explain to them what they're looking at there, Patrick?
Yeah, that's not good for us. You can see in that lower circle it says Other OTC. That OTC, I had to look this up, means over the counter. You also have another indicator where at the end of the ticker symbol it says .pk. And the .pk at the end of a ticker symbol means pink sheets. And these mean the same thing. Things that trade over the counter or quote-unquote on the pink sheets are not traded on an exchange. They're not registered with the SEC. They don't trade on a regional exchange. They trade investor to investor, financial institution to financial institution, and they are not listed. So they do not qualify for our definition of publicly traded.
Okay. So and I wanted to alert you to some other things here very quickly too, because we got a lot more to get through here. But I think all of this is good information for you to be able to sort of work your way through publicly traded securities. There are these other things that you might run into, like even particularly with Nestle, which are ADRs. They're American Depository Receipts. And I've given you an explanation for what these things are, and I don't think we need to go into that right now. What's important for you to know is with an American Depository Receipt, some of them are publicly traded. They're registered with the Securities and Exchange Commission and are traded on national exchanges. So just because you see ADR doesn't necessarily mean it's a problem. You're going to have to see if it's traded on a national exchange. But some are not. So again, you're going to have to look up ADRs and see whether or not they are or aren't eligible. And on the next slide, I gave you a couple of examples. The first example is for British American Tobacco. And you'll see on that one trades on the New York Stock Exchange. So that's an ADR, but it trades on a national exchange. It's registered with the Securities and Exchange Commission. That's eligible for an exemption. Whereas the Nestle one, I looked up Nestle's, even their ADRs are all sold over the counter. Again, so see that OTC indication, which means that it's not traded on a national exchange. So Nestle's ADRs would also not be eligible for the securities exemption. So just where are we now? A status check on where we are, because we've taken you through a lot of analysis here. The Conagra Foods is a publicly traded security, so those would be eligible for the exemption for publicly traded securities in terms of just generally because they are publicly traded securities, they're eligible. The Nestle stock, however, is not because it's traded over the counter. So the next question is, okay, well, so what is the nature of the matter that the employee is going to be working on? Because if you remember, we had 3 different types of exemptions that deal with these de minimis publicly traded securities, and now we need to figure out what kind of matter the employee is working on. So we have to say, is it what is the nature of the particular matter? And under A, we talked about, under 202A, we had said that it was a particular matter involving parties. And we have a definition for that in 102. So when you go to 102, a particular matter involving specific parties is defined at 102L, and it says that it's a judicial or other proceeding, application, request for a ruling, determination, contract, claim, controversy, charge, accusation, arrest, or other particular matter involving a specific party or parties. So what we're looking at here, specific party matters are things like what, Patrick? Like contracts?
Contracts are the one we see all the time, but also grants, investigations, licensings, litigation certainly qualifies. We can name the parties, so it's a specific party matter.
So that's exactly it. If there's a named party to it, it's a specific party matter. What's our matter? The matter we're looking at was what? We said it was
It's a regulation, right?
It's a regulation. It's a standard-setting regulation, and regulations don't typically have named parties.
Right, you can't really be a party to a regulation in most instances, right? It's just a rulemaking.
Exactly. So we have to look at whether or not this would fall within the ambit of that other particular matter definition, which is the particular matter of general applicability. And that's at 102M. And again, there, if we look there, it says it means a particular matter that is focused on the interests of a discrete and identifiable class of persons, but does not involve specific parties. So ours is a standard-setting regulation that affects whom?
The frozen food industry.
The frozen food industry. So can we argue that that's a class of persons?
I think they're discrete and identifiable. I think we could, if we thought about it, figure out what the universe of companies making frozen dinners is. And I think they would probably be affected as a discrete and identifiable class by this regulation.
Okay, so it looks like what we're looking at is the particular matter the particular matter of general applicability exemption. Looks like it's likely to be the one, if it applies. So once we go to that exemption, which is at C, so I'm chasing you around these regulations, and this is just the way it is when you're trying to follow these regulations to their letter. You really need to go back to the language of them. So if we go to 2640.202C, that's where we find the de minimis exemption for matters of general applicability. And if we get down to one little I, we know the securities are publicly traded for Conagra at least, and now we have to look at the market value. And the market value for a matter of general applicability is not more than $25,000 in any one entity, and no more than 50 in all affected entities. So if we look at the things that we set out from the very get-go, we know that the $12,000 in Nestle stock, we can't use this exemption. It's not publicly traded, so we can't even use the exemption. So we don't have to worry about how much that is, at least not for purposes of this exemption. So what we want to focus on is how much Conagra stock, which is eligible, how much do they have? And between the spouse and the minor child, there was only a total of $5,000, because you have to aggregate for everyone who holds it, employee, spouse, and minor child. And that's clearly less than 25 in one entity, which is Conagra, and certainly less than 50 in all affected entities.
And I think these situations are interesting, because here we'd be disqualified when we got to the Nestle stock. We couldn't participate in this regulation so long as we hold the Nestle stock, because there is no regulatory relief for securities that aren't publicly traded. But we do have an interesting thing here where if we asked our employee to, say, sell the Nestle stock, we'd be okay, right? Because we could then rely on the exemption.
Right. That's exactly right. So that's what. So what? So the takeaway from this is this exemption is only going to take care of part of the disqualifying financial interest that the employee has. It's only going to help with the Conagra piece of the disqualifying financial interest. It doesn't help us take care of the Nestle stock. We would still have to find some other mechanism to remediate that disqualifying financial interest before we could let our employee participate in the matter.
But it does give us some flexibility.
Yes, absolutely. Absolutely. Okay. So that was our first exercise. Exercise 2, we're dealing with the same particular matter. So we're still looking at the standard setting regulation that affects frozen food manufacturers. But now our employee has some additional interests. So in addition to the $5,000 worth of Conagra stock and the $12,000 worth of Nestle, this employee now holds approximately $10,000 worth of Conagra stock options and $15,000 worth of Conagra corporate bonds. Okay? So now we're going to be doing the same sort of process here. Again, same matter, different interests. We got Conagra options and Conagra bonds. Okay, so we're looking for will the outcome of the matter affect those holdings? So again, we have to look at the nature of these holdings. We talked about why stock was a conflicting financial interest. Now we need to look at why are options a conflicting financial interest, or are they a conflicting financial interest? Would you care to explain that a little bit, Patrick?
Options are interesting because they provide the right to buy or sell shares of a company for a given price at some point in the future. The net effect of this for our purposes is that an option actually will typically amplify a person's financial interest in the underlying security. So if you buy options to, say, purchase or sell shares of Microsoft Corporation 3 months from now at a given price, that arrangement is such that your actual financial interest per dollar invested is greater in the options than it would be with the regular shares. So we sort of treat them the same. We basically say that if you have options, you have a financial interest, the financial interest of the company whose securities you have the option to buy or sell, or your own. So we treat them just like stock. You stand in the shoes of the issuer of those securities, regardless of if you have an option or are just common shares.
Exactly. So for purposes of 208, for the conflicts purposes, we treat the nature of a financial interest in options as being tantamount to an interest in stock, which is to say, as Patrick said, you stand in the shoes of the company. Anything that can affect the company is going to be deemed to affect your financial interest if you hold either stock or options. But I do want to underscore the fact, when you have stock options, the employee doesn't actually hold the securities. The only thing the employee has is a right to buy or sell the security. They do not hold the security. So I want us to keep that in our head, because even though we treat them like 208 for purposes of the conflicts analysis, we're not going to treat them identically later down the line when it comes to the application of the exemptions, okay? So for right now, all we're saying is they are treated like 208, they are treated like stock, for purposes of 208, but you do not hold the security when you have an option. So that's the analysis for stock options. That's why 208 is a problem here. So now let's look at corporate bonds. Corporate bonds are a categorically different animal. Corporate bonds are a debt obligation of a company. I mean, with a corporate bond, effectively what you're talking about here is the company is asking people to lend it money. So when it's issuing a bond, it's saying, if you give me X amount of money through the purchase of a bond, I will repay you that money with a certain amount of interest. So it's a debt obligation. And so our analysis is going to be really very different in those cases, right? Because what would make us think that, what would be the effect we would have to have on a company when we're dealing with the fact that they are basically borrowing money from us? I mean, effectively, we'd have to make sure that they're that they're creditworthy, that they're good for the money. And that's really, in effect, what we're looking at. So when you're looking at a 208 analysis for a corporate bond, what you're saying is, would the outcome of the matter so affect this company as either to affect their ability or willingness to repay the debt, or, and this kind of ties in with that, could it affect their creditworthiness such that it would affect their credit rating or their bonds rating? Okay? So, I mean, if we think about that, I mean, the type of matter and the magnitude of the effect that matter would have to have on a company so as to affect its creditworthiness and its ability to pay its debt obligations, that would have to be a pretty profound effect from that matter. So unlike stocks, where we basically say, look, just about anything you could do is going to be affecting your financial interest as a stockholder because it's going to affect basically the bottom line of the company, where it's a very direct 208 conflict of interest. With corporate bonds, not so much. And so, like, even in this situation, I mean, if we're looking at the matter as a set of standard setting regulations that would affect frozen food manufacturing of these companies. Is it likely that that standard setting regulation would so affect Conagra or would so affect Nestle that would affect their creditworthiness? And chances are no. So arguably here, these corporate bonds aren't even a disqualifying financial interest for this individual, okay? Given the nature of the matter that they're going to be asked to participate in. So, you know, just to walk us through the exercise of applying the exemptions to bonds, just so that you see how it would apply, we're still going to carry them through to see whether the exemptions would apply to them. But for purposes of the 208 analysis, frankly, folks, I think we could stop here with the corporate bonds because I don't think this matter would so affect Conagra or Nestle as to affect either of their creditworthiness with respect to their bonds, okay? So once we go there, then we would have to determine which, if any, of the exemptions might apply. And again, here we're looking at whether or not the exemptions for publicly traded securities would apply to either our options or our bonds. So the next step in the process, I'm sorry if you go on to the next slide, which is 35. Again, we'd go back to the definition of publicly traded security. And I want to start with the corporate bond simply because, as I've highlighted here on this slide, and as you see, we saw in the definition, clearly corporate bonds are securities, and then it's simply a matter of ensuring that they are publicly traded securities. So in the case of Conagra was a publicly traded company.
Right.
So its bonds are going to be publicly traded as well.
Right, again, explicit in the definition.
Explicit in the definition. So I think, and I was just telling them that, you know, that it's, as you heard, that we probably aren't even dealing with 208 in this case because
right.
that matter's not going to affect
their
creditworthiness,
yes.
right? But just so you do know that bonds are eligible, publicly traded bonds are eligible for the publicly traded security exemptions. So we would be able to look to those.
And I find that kind of helpful when I'm doing an analysis because sometimes it's difficult to tell if a matter is going to affect the creditworthiness of a major corporation. Mm-hmm. And if we know that we have cover under the exemption, mm-hmm. we don't have to worry too hard about whether or not, you know, that analysis is correct. We can just rely on the exemption, notwithstanding the effect that there's probably not going to be a direct and predictable effect.
Exactly. So we know it is going to apply to our Conagra corporate bonds, but what about our stock options? Remember what I said a minute ago about that stock options are not the actual security itself. So the options are not a common stock. They are not a preferred stock.
Well, they're a contract between two investors that says, I will sell you X number of shares for X price, or I will buy from you X number of shares at X price at some date certain in the future. There's no security there at all. It's just an agreement. Exactly.
So it doesn't even meet the definition of security, much less publicly traded security. So our stock options are not going to be eligible for any of the publicly traded security DeMinimis exemptions, okay? So just so that everybody's aware of that, they get treated like stocks for 208 purposes, but they don't get the benefit of any of the DeMinimis exemptions. Again, going back to, we'd ask ourselves, what is the nature of the particular matter we're involved with? In this case, it's the same one as before, and we said that it was a matter of general applicability because it's a regulation. And if you go to slide 37, we're looking again at our latest interests, and we're saying, okay, the $10,000 in Conagra stock, their stock options do not qualify for the exemption, so we take them even out of consideration. But if we look at our Conagra corporate bonds, we have $15,000 worth of those, and we know they're eligible because they are publicly traded securities. So then we have to decide whether that in conjunction with that $5,000 of stock we said the employee already had make sure that that combination, that aggregation of the bonds and the stocks together still falls below the de minimis values, and it does. 15 and 5 is 20. So that's obviously well below the 25 and well below the $50,000
Yeah,
de
and
minimis.
this is a very realistic example, because sometimes you'll have a situation where an employee has both options and common shares, and you have a disqualifying interest because of the options. But often that's a very temporary exercise. You know, the options are going to mature at some time, and they're either going to turn into common shares or they're just going to expire without value. So it may be the case that you have a temporary recusal while the options mature. And then after they've matured and turned into common shares, you're able to use one of the exemptions, or they expire without value, and then you just look at the residual holding and find that an exemption applies and the person can resume participation.
Mm-hmm.
So I think it's a very realistic scenario that you might find with an employee or a financial disclosure filer.
Mm-hmm. And one thing, again, I do want to reiterate here is when you're looking at those $25,000 and $50,000 de minimis value levels, you only aggregate things that qualify as publicly traded securities for purposes of aggregating those 25 and 50. So, for example, the amount that we had for the Nestle stock doesn't have to get factored into that 50,000 for all affected entities. Yeah, is Nestle an entity that's going to be affected by the matter? Yes, but their securities aren't publicly traded securities, so you don't have to aggregate those into and factor those into along with the Conagra stock, which does qualify for that exemption. So the only thing that gets factored into those $50,000 value amounts are those things that actually qualify for the exemption to begin with. Okay, very good. Okay, so that gives you a nice introduction to, and hopefully has given you a little bit of a flavor for how the de minimis securities exemptions apply, at least the ones that you're most commonly going to be using. There is a third, de minimis exemption for publicly traded securities that I want to give just a very quick sort of explanation for, and that's at 202B. And that's the de minimis exemption for matters affecting non-parties. And it seems like a kind of a squirrely exemption. So sometimes the best way to explain this exemption is just by way of illustrative example, you know? So I think the most commonly occurring way that this exemption would come into play is, again, in the case of like a contracting matter. So let's say that there was a company was awarded a contract, and one of the companies that did not win the contract basically cast a bid protest, okay? And so the company that is engaged in the bid protest is clearly one of the parties to the matter.
The matter of the bid protest.
The matter being the bid protest. So the bid protest is the matter, and the party that is engaging in that protest is clearly a party to the matter. But obviously, any other companies that may have originally competed for that same contract, you know, have also an interest in the outcome of that bid protest. They're not parties to the matter, but they're sitting out there watching, and they clearly have an interest in the outcome of that matter.
Because if they had to say recompete, they could potentially be bidors or even winners of the recompeted contract.
Exactly. So this exemption would apply if your employee had not a financial interest in the bid protester, but a financial interest in one of these other parties who are sitting out there looking in on this bid protest. They're non-parties who can be affected by a specific party matter. And that's really where this exemption is intended to assist, is in non-parties who could be affected by a particular matter involving specific parties.
I think this is a good reminder in general when we talk about 208 potential conflicts of interest, that non-parties can create disqualifying financial interests. You needn't be a party to a specific party matter to be directly and predictably affected by the specific party matter. You know, so competitors, subcontractors, other kinds of parties or non-parties can be affected by specific party matters without being named parties.
Exactly. Hence this exemption. So hopefully that gives you a little bit of a better understanding of what that exemption was was intended to cover. Okay, so let's move on to employee benefit plans. Here we're dealing with a different section of 2640, so just so that we know where we are in 2640 as we start talking about the exemptions for employee benefit plans. These are housed at 2640.201C. So I want to give everybody a chance to get there because there are several of them. And I'd like everybody to just kind of familiarize yourself with where they are. One of the key pieces to the C1 provision in the employee benefit plans exemption, and there are going to be 3 different things to which it applies, but the C1 paragraph applies in the context of all 3 of these. And so what C1 says is that this is going to enable, this exemption allows an employee to participate in any matter. Notice how this isn't going to distinguish. I mean, C1 is not going to distinguish among or between different types of matters. It's basically saying any particular matter affecting one or more holdings of an employee benefit plan where the disqualifying financial interest in the matter arises from membership in, and then we go on to talk about the types of plans that are eligible for this exemption. But what this exemption is reaching to are the underlying holdings of those plans, and whether the disqualifying financial interest is by virtue of an underlying holding in one of these types of plans, okay? So when we talk about underlying holdings of the plans, we are talking about basically defined contribution plans is effectively what we're talking about here. And we're going to talk about each of these discretely as we go through our exercises. But just so you understand that the C1 provisions are dealing with any particular matter, so it's going to cover any particular matter, but it's really focusing on when the disqualifying financial interest comes from an underlying holding in one of the types of plans that are articulated in this employee benefit plan exemption, okay? So if we look at our first example, the first example is you investigate discrimination complaints in HUD's Office of Fair Housing in the Philadelphia Regional Office, okay? So that's the kind of matters we're looking at. We're looking at investigations of discrimination complaints in fair housing, okay? You previously worked for the City of Philadelphia and you've retained an interest in its 457 deferred compensation plan. Okay, a 457 deferred compensation plan. We're going to talk about that a little bit more in a minute. One of your investments through the plan is in the T. Rowe Price Real Estate Fund. And that fund invests 80% of its assets in the equity securities of real estate companies. So just as we did in the last set of exercises, Patrick, what gives you pause here? I mean, why would we be concerned about 208 given this fact pattern?
Well, it seems given that our employee is an investigator of discrimination complaints at HUD's Office of Fair Housing, and the people that he or she is investigating are probably real estate companies or companies in the real estate industry, and they have this holding that is a real estate fund. There's a potential nexus there. We don't know specifically whether or not that would create a disqualifying financial interest, but they're sufficiently close that we at least have an inclination that there may be a disqualifying financial interest.
Exactly. So it's the nexus between the nature of the type of investigations and the entities that are likely to be affected by the outcome of those types of investigations. And so we've got what we think might be a nexus here, so that's why we're concerned about this under 208. So if we go to the next slide, we have to decide which of these employee benefit plan exemptions may or may not apply, because we're dealing with this is a holding in a 457 deferred compensation plan. So we're dealing with some sort of employee plan from a former employer, okay? So it behooves us to look at these exemptions to see whether any of them might apply. If we look at the first one in 201C, we can sort of immediately eliminate that because that one is targeted specifically. If we look C1, one little I, that's only going to cover the thrift savings plan, and as we all know, that's our federal government defined contribution plan. So unless it's dealing with TSP, and this one is clearly not, we can just move on to the next one.
Incidentally, that's why we don't need to report the TSP on our financial disclosure reports.
Exactly, because it's already been exempted. So if we look at the next one, now we're looking at that the employee can participate in any matter where the disqualifying financial interest arises from the underlying holdings of a pension plan established by a state government or a subdivision of the state for state and local employees. So the threshold issue here is that does a 457 deferred compensation plan qualify as a pension plan? And the short answer to that question, sort of in the interest of time here, is that yes, it does. 457 plans are very typical for state and
local municipalities.
Local municipalities, as are like 403B plans are also very common among state, local, and nonprofit types of organizations. So when you see things like 457 plans and 403Bs, understand that those are largely tax code references.
And this isn't, there's some sensible basis for this particular exception, in that the tax code that undergirds the pension plans for state and local governments, so Section 457 or Section 403B, contains restrictions on the kinds of assets that can be offered through the plan. And those assets tend to be cause us less concern when it comes to conflicts of interest. So that's kind of the logic behind this portion.
Yeah, because the cause for exactly that the very nature and the very restrictions that are placed on the plans themselves are going to make it very unlikely that the underlying holdings would be of particular concern for purposes of 208. So a 457 deferred compensation plan does qualify as a plan. And if we go to the next slide, we're going to sort of highlight this for you in this example. On the next slide, we basically say, okay, so you have a 457 deferred compensation plan, which is a pension plan, and who is it sponsored, established by? It's established by the City of Philadelphia. Is the City of Philadelphia a political subdivision of a state? Yes, clearly, the City of Philadelphia is a subdivision of the state of Pennsylvania. And the T. Rowe Price Real Estate Fund is one of the underlying holdings, and that's the thing that's causing us heartburn. So clearly, based on our facts,
the plan is exempt.
The plan is exempt. So you don't have to worry about the T. Rowe Price Real Estate Fund or any other underlying holding of that 457 deferred compensation plan.
And remembering this one can be a big time saver because you don't have to sort through all of the various underlying things. You can look at the top tier plan and know that the exemption applies, and then you're sort of in the clear.
Mm-hmm. Now, if it weren't a state-sponsored plan, if the plan itself weren't exempt, then you should look to see if there might not be some other exemption that would apply. Right. Whether it was one of the diversified mutual fund or the sector mutual fund, or if it's an individual security, whether or not it would meet the security exemptions. So just because the plan itself is not going to, or like all of the underlying holdings aren't going to be exempted under this particular exemption, you might still discreetly be able to find a different exemption that would apply to that particular holding. Okay, the next one, exercise 4, if we go to the next slide. Here we have an attorney at the Consumer Product Safety Commission. Prior to that, they were an in-house counsel at Sharp Toys, and Sharp Toys provided its employees with a 401k plan. And this plan was administered by Integrity Inc. And through that 401k, the individual had selected various individual stock holdings. One of them is $14,000 in XYZ Corporation, and now CPSC has asked you to participate in litigation against XYZ Corporation. I think, again, we're looking at a stock holding here, we're looking at a security,
yep.
So it's kind of a direct 208 conflict concern.
So we're standing in the shoes of XYZ. This is going to get a little interesting, I think.
Yes, it is. And just as we said before, there may very well be an alternative exemption that you could use in this case, which is to say one of the security, like the publicly traded securities exemption, if it qualifies for that. But I think it behooves us, since it's in an employee plan, to see whether or not that particular exemption might also capture it as well. So when we look at 201C1 3i, here we're looking at the underlying holdings of a diversified employee benefit plan. And here's what it has to be administered by an independent trustee.
So that means not the employee. The
Not the
employee
employee.
cannot be the person accepting or making the investment decisions.
Exactly. It doesn't have a profit sharing or stock bonus component to it.
Okay.
And then neither the employee nor any other person named in 208A is able to select or designate specific portfolio investments.
So these would be like individual securities. We can't say I want to own X number of shares of Berkshire Hathaway.
Exactly. So we need to then look at our fact pattern and see what conundrum this presents for us. And Patrick, you kind of nailed it right on the head. The thing that sort of immediately takes this out of the ambit of this particular exemption is this very fact that we've highlighted here on the next slide, which is you have selected various individual stock holdings. Okay?
So our employee picked XYZ Corp. He said that I'm going to go buy some. It's in my 401k, which provides me some tax advantages, but basically it's as if he decided to go buy these shares on the common market.
Exactly. So this would not, he would not be allowed to avail himself of this exemption for employee benefit plans. He could only perhaps avail himself of the DeMinimis Securities exemption if it falls within that the elements of that, and it's at 14,000. And we know that for specific party matters, because he's doing litigation, so if any of them applied, it would probably be the specific party matter one. And he's at 14,000, and the de minimis for that is 15K.
Yeah.
So he's within the exemption, but what might we want to let him know that he's on?
We'd probably want to let him know that he's pretty close to the edge of not being covered under the exemption.
And depending on how volatile XYZ Corp stock is, it could go up or whatever over 15 at any point. And once he's over 15,000, he's back in 208 land. And the minute he participates in that litigation and he's over 15K.
Checking that every day or twice a day can be sort of burdensome for an employee.
Yeah, the due diligence on that is enormous.
It may be in our employee's interest to divest himself of some of these shares so that he's more comfortably below the exemption threshold.
Well, plus, and also just, it might just be in everybody's interest and in the agency's interest, most importantly, to not have him be conflicted at all, which is to say if he's going to be participating in litigation, that he shouldn't have any financial interest in XYZ at all. So it might just be prudent to have him divest himself completely. Okay, we have one final exercise, which is you're an attorney for the IRS. You previously worked for University of Maryland's Law School. U of M has provided you with a defined benefit plan. Ooh, this is a different kind of plan. The IRS is considering substantially raising the taxes that state universities must pay. Okay, so the matter is a tax issue involving state universities. What kind of matter does that appear to be, Patrick? That's going to be a matter of general applicability, I think.
I think so. I don't think you can be a party to the tax code, except in the context of an audit. But in this case, we're talking about a change in regulation, so it doesn't seem like a party matter. So
we're looking at a matter of general applicability, but that it's clearly going to affect the University of Maryland, and you have a defined benefit plan with the University of Maryland. So the question is, there's a threshold question about whether or not you even have a 208 conflict here necessarily, and whether or not it would, directly and predictably affect your financial interest in the defined benefit plan. But assuming that it would, assuming that we are concerned that 208 could create a potential conflict here, there's an additional exemption in the employee benefit plan, which is at 201C2. We had been talking about 201C1. Now we're looking at C2. And here's C2. It's a narrower exemption because right out of the box it says particular matters of general applicability, such as rulemaking, affecting the state or local government sponsor of a state or local government pension plan described in paragraph C1(2) of this section, where the disqualifying financial interest in the matter arises because of participation in the plan.
So this is tricky. There are a lot of boxes we have to tick in order to rely on this, and there was probably only a finite number of matters that would implicate this where we'd even need it. But so we're only talking about particular matters of general applicability that affect the sponsor or state government sponsor of a pension plan. So that's interesting.
Yeah, so we're looking, it's a very focused one, and if we apply that, if you go to the next slide and we apply it to our fact pattern, we know that the matter that he's being asked to work on is a matter of general applicability. It's a rule. It looks like it's the tax code, so it's a regulation. Okay, so it looks like we're cool there. So then it's that it's going to affect the state or local government sponsor of a state or local government pension plan. Well, it's going to affect the University of Maryland.
Right.
Is the University of Maryland a state or local government?
Yeah, I think they're a subdivision of the state government. They're a state university. If they're a private university, we couldn't use this, right?
Exactly. So we're looking at University of Maryland and we're thinking it applies here because you want to double check because not all schools that you may think are public universities are necessarily public universities. They may not be entities of the state in which they reside.
There are a number of Florida universities that always get me in trouble there.
Exactly. So you want to be extra careful and not just assume something's a public university. University of Maryland does happen to be, and so it would qualify as a state or local government pension plan. And the disqualifying financial interest arises clearly because of participation in the plan. It's not dealing with the underlying holdings of the plan. It's dealing with the financial interest is in the plan itself. So in this instance, the exemption at C2 would apply, and it would take care of any financial interest that comes about as a result of participation in the defined benefit plan. We've given you on the last slide just some resources for you to become familiar with. Obviously 2640 has got to be your Bible, and it's got to be something that you go to every time you have a question. There are various diagrams that we think are useful too, dealing with diversified and sector mutual funds. The particular matter involving specific parties, particular matter, and matter is absolutely critical. If you don't have that in your toolkit, if you have not read it, you really need to read that because it's really fundamental for you to understand the distinction between different types of particular matters. We have something on waivers under 208 if you're interested in learning more about that. And then in terms of the financial instruments, we have a couple of guides on our website which you can find under the Public Financial Disclosure tab on our website. And each of these guides is really good because it gives you some indication not only of how these things would be reported on a financial disclosure form, but also give you some sensibility about the kind of conflicts analysis that would attend to each of those types of holdings. Do you have anything, final words of wisdom for anybody, Patrick, here before we open up the lines for any questions?
No, I think the biggest takeaway is to remember to go back to the regulation. I find it helpful to scan through the entirety of the regulation. Because oftentimes you'll find yourself sort of getting in a pretzel to figure out if an exemption applies when there's another one that more obviously applies and takes care of your problem. So sometimes there are specific exemptions that can remedy a problem more easily than some of the more general ones, and that just keeping that in mind is important.
So if we could open up the lines, if anyone on the phone has any questions, or if anybody on the Hangout has a question, please
take any of those.
Yeah.
Thank you. At this time, if you would like to ask a question, please press star 1 on your telephone keypad. That is star 1 to ask a question. One moment, please.
Thank you.
And I'm showing no questions on the phones at this time.
Okay. Yeah, well, if there are no questions, thank you all very much for attending and your participation. We're happy that you were able to join us, and we look forward to seeing you in future distance learning events. And thank you, Cheryl, very much for joining us on the Fundamental series.
Yeah, it was a pleasure. I enjoyed it very much.
Excellent. We'll see you guys next time.